Brittany. I'm Ben Frost. I'm the Professional Development Officer for the Northern New England chapter, and I'm really happy to have you all on this webcast today. I met Jerry virtually through email through a mutual friend of ours when he alerted the New Hampshire planning community to a bill that was in our legislature, one that had slipped by me, even though I tracked the legislature pretty closely. And it deals with the FCC guidance, and the bill would incorporate a lot of what the FCC was saying in its guidance, and in essence take away a lot of local authority to deal with expansions of existing telecommunications facilities. And so with his generous guidance, we were able to make some changes to the legislation, which has now passed the legislature in better form, although not perfect, better form than it would have been originally. So let me introduce Jerry. Jerry is of counsel to Best and Krieger in their municipal law practice in their D.C. office. He has a long history and really
Ben, don't tell people I can't hold a job, please.
He's held many positions of importance in dealing with municipal regulation, and also is currently of legislative counsel to Telecom Unity, which is a collection of local governments that are dedicated to local rights. And he's not shy about defending municipal authority and advocating for it. And he actually wrote wrote the first model license agreement for access to municipal buildings and rooftops to help telecommunications service providers protect their interests. And has a variety of other positions. He's admitted to practice in the state of New Jersey and D.C. and in the Commonwealth of Pennsylvania. He's a graduate of Temple University Law School and Haverford College, and I'm very happy to have him on this webcast today. Jerry?
Ben, thank you so very, very much, and everyone, welcome and thank you for joining us. I really do want to thank Ben for introducing me and for introducing me to this whole program that APA has. As Ben mentioned, I've been in Washington for quite some time, in fact, since 1985, and in that time I have represented almost exclusively local government interest. And as the years went on, I went from being the general counsel at the U.S. Conference of Mayors, where I had a broad portfolio, to becoming more of a specialist in the communications area. And so my firm for years was a firm called Miller & Van Eaton, and we were acquired by Best and Krieger about 2 years ago. And so what we do is we try to protect local government's interest in this intersection between typically real estate and or planning/zoning and the communications world. It's a Friday afternoon. It's a Friday afternoon in the summer. It's pouring, rotten down, raining here in D.C. It's pretty glum. I got to figure out how to make this exciting for you all. And unfortunately, I think the best way to make things exciting is to tell the truth when things are scary, and this should be scary to you. The planner's nightmare is really federal and state preemption of local wireless authority. And what we'll do is we'll go through a couple of different areas where you're being threatened. If I could, I'm going to put this up on the screen for about 1 second and then get rid of it. My marketing people always make me at least put one slide up about Best and Krieger. We're very proud of the fact that we only represent municipal interest, and for that reason, we're proud to never be conflicted out of work unless it's a litigation between two communities. But so if you find yourself in need, and not just in the telecom area, but water, environmental law, finance, more than happy to help. And again, I apologize, but this way my marketing people don't throw me out. So what are the goals of our program? Well, let me tell you my unstated goal. The American Planning Association has incredible credibility here in D.C., and it always has. I love when I can reach out to the APA and the American Public Works Association, because both of your organizations are viewed as the real people on a day-to-day basis that have the challenges of keeping cities livable and keeping them, to some way, shape, or form not subject to environmental blight. or visual blight by some of these developments. And so my unstated goal is very simple. I'd like to do my best to help educate and bring some of these issues to the APA, with the net benefit being to me, my clients, and local government that we have an influential and an informed APA. But beyond that, what I'd love to do is to provide an overview of the evolving federal standards that are affecting local authority to control the zoning of wireless facilities. And by wireless facilities, because Ben's been kind enough to give us this 90 minutes, we're also not going to talk about just cell towers, but for the last few minutes, we're also going to talk about some of the rules that impact satellite dishes, because in fact there are 3 major metropolitan areas that have satellite dish ordinances that have been stayed, the effectiveness has been stayed by the FCC, and that's Boston, Chicago, and Philadelphia. So hopefully we'll talk a little bit about that at the end. But what we really are focusing on primarily is wireless facilities, that is cell towers, collocations on those cell towers. Cell towers is sort of a catch-all phrase, and you all know that, because a cell tower may in fact be a deployment on top of a rooftop, or it may be on top of a telephone pole, etc. So when we're talking about wireless facilities, use your imagination and understand that we're trying to talk about as broad a category as possible. I'll tell you what we expect next at the FCC, and then as Ben indicated, how we got to know one another, discuss how state laws related to these new federal standards are coming about, and where we've seen them, what you can expect, and just how fast these things move. Again, thanks to the leadership of Ben and others in the planning community in New Hampshire, that bill is not nearly as bad as it was when it started. And I think Ben's experience will point out that most legislators, once you point out to them or you can educate them on some of these issues, will respond, and so we can go from there. So what's the overview? Well, the first part of the overview is that this problem is not going away. Those of you who thought that at some point the challenges that you face locally on the siting of cell towers or other cell devices would slow down because, my God, how many can you deploy and how many do you need? Well, remember, we're now into 4G, which is the 4th generation of these services. So every time you roll out a new generation, again, this is a little bit overly simplified, but every time you roll out a new generation of wireless, what you're basically doing is you're reducing the size of the cell or the size of the geographic area that cell site serves. And the reason that you do that is that you have to, because the only way that you can meet the increasing demands for data, wireless data transfer, is to use the spectrum most efficiently or reuse the spectrum most efficiently. So if I take a cell site today, or the original ones, and say it was a mile square, and we're now down to about 16 boxes within that cell site. And why is that? Because that increases by a multiple of over 16 how many times you can reuse that spectrum, and that's how you can meet demand. So here's a chart that just shows you that from CTIA, that's the industry, that AT&T Wireless alone, right? So that's not Verizon, that's not Sprint, that's not T-Mobile, that's not the other crickets, the independents of the world, alone plans to deploy over 1,000 distributed antenna systems and 40,000 small cell systems moving forward. And the numbers will continue to increase, so the problem is not going away, it will only increase. And the other thing that you want to know, and the new trend, is this DAS. DAS stands for Distributed Antenna Systems. The difference between DAS and other towers is that DAS are often installed to lease to others. So I'm the company that owns the DAS company, the DAS equipment. Many times I'm not the one that's providing the service. I'm sort of this mini tower system that sets up, and then others come and use it. Now, because it's smaller, we're seeing a lot more challenges with respect to putting those devices in the rights of way. And we now have 2 issues that are impacted, right? Because it's not only your wireless ordinances that are impacted, but now we're talking about your rights of way ordinances that are impacted. And what are these DAS people? Are they a wireless company, or are they an occupant of the rights of way, and there are different rights and privileges that each of them get, and sometimes it's somewhere in the middle. And then again, there are many, many different types of installations. Some of them are intrusive, some of them are not. They involve antennas, boxes on poles, cabinets on ground. So that's the common theme, right? You're always going to see an antenna, you're always going to see some sort of a box on the pole or a cabinet on the ground. One of the great statements that's made over and over again, and Ben, you tell me if I have it wrong, is that the secret about wireless telecommunications is that it's anything but wireless. Right? The only thing that's wireless is the last connection to the user. Everything else in the infrastructure of that environment is in fact wired. And again, hundreds of thousands of these are likely to be installed. And so here's an example, just a single page, giving you a flavor for what these new systems may look like. And if you look on the far right, you can see some of them are amazingly unobtrusive, right? I mean, that's a simple, looks like it's a simple extension of of the light pole. Others are a little bit more visible, a little more obvious. But these are the ones that the industry will always show you, the ones that blend right in and aren't a big deal. That's not necessarily what you're going to get in the future, and the reason for that is because of the collocation by right language that we're about to talk to. Before we can do any of this, and I promise that this is not Law School 101, but all of you should know these things because these are your rights and privileges, but also your limitations as you move forward. The federal government has, since about 1996, been looking at ways to address and preserve local zoning in terms of telecommunications infrastructure, whether it be wired or wireline. Section 253 of the Communications Act, so that's 47 U.S.C. 253, prevents state and local laws that prohibit or have the effect of prohibiting the ability of any entity to provide telecommunication services. But it has some carve-outs, it has some safe harbors. And the exceptions are that local governments, planners, get to retain your police powers with respect to regulations, rights-of-way management, and the ability to require compensation for use of the rights-of-way. Now that's what the federal law says. I don't want to confuse anyone. A number of your states, as I looked at the list, and again, thank you all for being here, a number of your states have surrendered rights-of-way or they've compensation, or they've put a cap on it, but that's not what federal law says. The federal law says that you're entitled to that. And the FCC has stated that this provision does not apply to the siting of personal wireless facilities, right? And that's where the debate will come in many of your communities. Is a DAS a personal wireless facility? The other section of the 96 Act, which is vitally important and plays a role here, is Section 332C7. And what Section 332C7 said is that localities maintain control over the placement, construction, and modification of any personal wireless service facilities subject to certain limitations. Now again, this is what every one of you lives every day, so I'm not telling you anything new here, but sometimes it's good to review. Under 332, some of those limitations are that you can deny so long as the local regulation does not unreasonably discriminate among providers of functionally equivalent services. So you can't say that one system can go there and another can't if they're functionally equivalent. And you cannot deny if it would have the effect, it would either specifically prohibit or it would have the effect of prohibiting the provision of personal wireless services. Tells you a little bit more. The federal law says that a locality must act on a siting request within a reasonable period of time. Now, again, hopefully everyone has been following this. It's this section of the law that has been contested lately. The FCC, and we'll talk about it in a second, issued their shot clock. And we, on behalf of local government, challenged that shot clock as to whether or not the FCC had the right to define the terms. And that is, you have to act, a reasonable period of time is defined under the FCC rules now as 90 days for a co-location, 150 days for a new tower, and then within that shot clock, there are two mini shot clocks of that tell you how much time you have to tell the applicant that their application is complete, because the 90 days and the 150 days run from the acceptance of a complete application, but you don't get to have that open forever. You have to tell them within a specific amount of time whether or not their application is in fact complete. Again, federal law says that you have the right to deny, and if you do deny, that denial has to be in writing, and it has to be supported by substantial evidence in the written record, right? So again, you all live this every day. I mean, this is sort of the zoning code. You know, what is it that what have you based your decision on? So you want your record to be as robust as possible, and you need to do it in writing. It says one other thing. It says that localities may not deny based on RF concerns. RF is radio frequency concerns, as long as the facility complies with the FCC's regulations on RF emissions. Now, those of you who are in this business full-time probably would educate me on the fact that probably 90% of the complaints or the issues that your community has on the siting of a tower has to do with what is the impact on radio frequency on the kids that walk by and the people that live in the neighborhoods. And we clearly understand that, and you know, it's important for you to be able to say to folks, we're not even allowed to ask that question. That is the exclusive domain of the FCC. I will tell you, though, and my contact information is at the end of this presentation, that the FCC has just released a notice of proposed rulemaking in which they're asking folks, do they need to upgrade or update their RF emissions? So those of you that are out there that would like to be active in that, please simply send me an email and I'll send you the link to that, and it'll give you the time frame. One of my colleagues, Jim Hobson, in fact, just wrote up a small summary of it and with suggested comments that people might want to do. So if folks have interest in that, let me know. And then finally, if you deny, and you have denied it based upon substantial evidence and you have reduced that denial to writing, you give that to the you give that to the applicant. The applicant only has 30 days within to file an action in a court based on that failure. So then there's a shot clock on them. So that's where we are. So that's the act. That's round one. That's 1996, the Communications Act of 1996. In November of 2009, the FCC came out with a declaratory order on shot clock. And again, I'll read this quickly because we've already talked about it. What the FCC does is it defines, and I'm going to take away, defines presumptively, and the reason that presumptively is underlined is that these are not hard and fast dates. If the 150 days and the 90 days don't work for both parties, both parties can get together and mutually extend. If you can't get it done because of extenuating circumstances and the your industry partner on this refuses to agree to an extension, you can still go to the court and say, you know, this is why we couldn't get it done. The FCC does not say that there is no reason that you would go longer than that. They're just saying, presumptively, we determine that these are the time periods. 150 days for a new tower, 90 days for a co-location. The FCC also, in the declaratory order, defined what is effectively prohibited. Because remember what we said before, one of our limitations under federal law is that we cannot prohibit or effectively prohibit the provision of the personal wireless services. And the shot clock made very clear that you can't deny solely because one or more carriers serve a given geographic location. And if you look back, you'll see that there have been made, those types of decisions have been made in the past, where people will say, we don't need another tower here because there are 2 other carriers already in place and we don't need a third. You know, in the past, in some places, that was actually defensible. After this order, after the declaratory order of November 2009, that's no longer defensible. Right? Most courts are going to defer to the FCC on this determination, so make sure that that is never the grounds that you use for denying the grant of either a co-location or a new. And then finally, the remedy, court action, where court decides if local action complied with the law. Okay. So now, we've got the FCC, we've got the 96 Act, we've got the shot clock. Now, the FCC now wants to sort of expand on this, and it's asking, what are the impacts, or what is the effect of local regulation, or sometimes they call us regulatory underbrush. What is the effect of this regulation on the ability of folks to deploy these new technologies, whether it be a broadband by wire or broadband wireless? And they're still asking this, and it's being done on a case-by-case basis, but nothing has happened. Round 4 was this past a year and a half ago. The Congress passed a new law called, some people call collocation by right, collocation statute, but in 2012, Congress created a new section of the Communications Act, which is now 47 U.S.C. 1455. You may hear it also referred as Section 6409, because that was the section of the Act that this language was found in a larger tax bill. But what this new language says is that a state or local government may not deny and shall approve any eligible facilities request for a modification of an existing wireless tower or base station that does not substantially change the physical dimensions of such tower or base station. And then it defines eligible facilities request as any request for modification of an existing wireless tower or base station involving co-location of new transmission equipment, removal of transmission equipment, or replacement. And it further gave the FCC authority to implement it. Now, every one of those, see if I go back. Yeah, good. Every one of those underlying words are words that we believe have significance. And a lot of them are not defined other than eligible facilities request. And then within the eligible facilities request, the question is, what's an existing wireless tower or base station? We think we know what that means. The industry many times aggressively tries to expand it. And that's what happened in New Hampshire with Ben's legislation, is that what the industry did was it sought to go in and try to expand or define those terms. So the FCC then came out in January of this year with what they call the Staff Guidance. And in that Staff Guidance, they define substantially change through criteria that were developed in a different context. They were developed in both historic preservation and in migratory birds and migratory bird patterns and how big towers could get. And they said that, for example, no substantial change if an addition extends a facility less than 20 feet in any direction. Now, the nice thing about Ben's language is that they do away with that, and they do it with respect to the size of the tower. So, I mean, 20 feet in any direction, if you're talking about a monopole, well, that substantially changes that pole. But if you're talking about a traditional tower, which is, I don't know, 20 yards on each base, then 20 feet may not. So, I mean, this is the big problem. The other thing is that it offers a broad definition of a base station, and that it could make the statute applied to many facilities, including utility poles. And so this is the whole idea that they could come in and mandate that your governance, your management of some of your poles might not, in fact, continue to exist because it's a base station, and they'll cite to this language and say you cannot deny and you must approve. And it does not discuss safety issues, proprietary property, or non-zoning rules that may affect placement. So one of the things that we're intrigued by, and I hope that all of your communities are renting out rooftop space or renting out ground leases to these tower companies, because it's nice ancillary income for your community. And in many cases, I've been able to negotiate over the years, free carriage or free placement for, my clients' public safety users on such towers. So I'd really encourage you to involve your proprietary property. But the question is, wait a second, is this applied to me as just the regulator, or does it also apply to me when I'm the landlord? So if I don't have terms in my ground lease or on my rooftop agreement that provide for additional compensation for co-locators, does that mean that they can cite 6409 as a justification that I can't fight it? Well, we think that that's not the case, but please beware. There are some in the industry that will try to move that way. And this new guidance is non-binding, and it's important that you all understand that. If somebody comes to you and shows you this guidance, this document from the FCC staff that was released in January of this year, you know, you're not bound by it. I think you want to pay attention to it, you want to work around it, but you're not bound by it. So if they're trying to say that you've got no flexibility because of the staff guidance, tell them that's just not true. And then, but there are serious questions raised in it, and where I think we're leading is that we're expecting next at the federal level that at some point, and I thought it was going to happen this month, I still think it'll happen before the summer is over, that we will see a new rulemaking on tower siting and on co-location and what it will do. And it will, and the reason, one of the things I didn't tell you is that the Supreme Court did review a case, Arlington versus FCC, that was brought challenging the legality of the FCC's rules. The Supreme Court didn't actually accept the case with respect to the underlying substantive rules. It accepted it on whether or not the FCC had jurisdiction and whether or not it was entitled to deference in finding its own jurisdiction. And again, if anyone wants a greater discussion of the Arlington versus FCC case, please send me an email. My colleagues represented Arlington, or actually represented local government in the matter, and I can send it to you. But because the Supreme Court held for the FCC, we think that their delay in moving forward will now go away. The only other thing that might keep them from moving forward is that the FCC right now is down 2 commissioners, Chairman Genachowski and Senior GOP Commissioner Robert McDowell. Both have moved on, and the President has nominated a fellow by the name of Tom Wheeler to be the successor to Chairman Genachowski as Chairman of the FCC, and we're waiting for the Senate GOP to share with the President who they think it should be. It should be their new Republican commissioner. So we probably won't see a fully staffed FCC until the fall at the earliest. But the folks that are there now, because most of this is being done at the staff level, I suspect we'll still get a ruling out this summer that will look further into the rules of shot clock, collocation, DAS, and small cells, and also that RF rule exposure rulemaking that we talked about. And it will be vitally important that planners across the nation are involved in sharing with the FCC how these things do not work and what the law of unintended consequences truly is when it comes to these things. And again, here's the information on the RF issues. I'm not going to spend much time on it other than to say, here's the information, here's the docket, and if folks are interested, please feel free to send me an email, and I will send you the summary and the information done by my colleague Jim Hobson. But it is clear that the Commission looks to do a proceeding this summer. Former Chairman Genachowski said that he wanted to have an action in the coming months to further streamline the DAS and small cell deployment. He also wanted to examine whether current application of the tower siting rules are providing sufficient clarity to both industry and municipalities. And he also wants to develop model facility siting rules for localities. Commissioner Pai, who's the new Republican commissioner, there are 5, so we have 3 right now, 2 Democrats, 1 Republican. Commissioner Pai, one of the lone Republican, says that he believes that there needs to be additional relief for wireless because you planners and local government people are really slowing things down. And for those of you in California, please know that he cited you all as especially troubling. So it might be especially important for you all to participate. But I don't want to make this partisan because Commissioner Rosenworcel, Jessica Rosenworcel, who's a Democrat, has called for there to be the development of model ordinances. Now, she doesn't think that they can enforce them. She's not going that far. But again, it might be something that the industry and local government might be able to come up with on a national level for people to review. So the translation on all of this is that significant federal actions are likely to happen soon. I think it's going to be sometime this summer. Expect that we will see them implementing Section 455. Again, 1455 is the collocation by right. Also expect action to address DAS installation. If for those of you out there that have those types of questions, understand that it's coming and you need to be active. And that expect that there will be specific communities targeted as problems that justify these restrictions. We've seen this show before. The industry will come in, and a lot of times they won't even identify you. They'll come in and they'll say something like, a county in northern New Jersey required us to wait, 140 days before they would even accept our application. And what we've done over the years is and not when I say we, I mean myself and as well as people that work for the Conference of Mayors, the League of Cities, the National Association of Counties, and the National Association of Telecommunications Officers and Advisors. What we have tried to do is we've tried to reach out to APA and to the American Public Works Association and say, help us identify these communities so we can tell the other side of the story. Because what we find is that, yes, it did take 140 days for that application to be reviewed, but the reason it took 140 days when you talk to the county that was in charge was because it was given back to them 3 times for being incomplete, but they're not going to tell you that. The other thing that we find is many times a lot of the citing, and you know this again, I apologize for being pedantic, because you know it better than I do, a lot of the citing applications are not made by the companies, the carriers, but they're made by these citing companies or these real estate interests on behalf of the cell companies or the tower companies. And it's a little hard for them to go back and tell the people that are paying them significant money to do these sightings, oh, well, we blew it because we didn't have the right information. So you go back and you badmouth the local government, you badmouth the zoning board, you badmouth the planners, because it's easier to blame you all rather than to tell the truth that they didn't do the things that they were supposed to do. So again, we need to make sure that we respond. We respond by making it clear to the FCC that in the past, that many times they have criticized us without even having our input, and they need to be able to do that. They need to make sure that they give each locality that's maligned the opportunity to be heard. They need to be able to distinguish between proprietary property issues and safety issues over and above the deployment issues, because many times these are so very important. And guidance, we need to make sure that we're not found to have, in fact, slowed wireless deployment, because, again, we think that history is on our side. Now, you're all going to shoot me because you're going to say, Jerry, you're in the next 3 minutes, you're going to show us photos that are going to better clarify everything that you've just said. Why didn't you just start with this? And I should, but I didn't. So in the classic case of about a picture giving 1,000 words, I just want to show you some mock-ups that we have done. So here we are. We've got a historic site. If you look at the tower to the right is actually a cell tower. It's a cell tower that was made to fit and look like a silo. Because of the new collocation by right statute, there's nothing that prevents the industry from coming in and doing this. Because while they have to file, we believe they have to file an application with you, your rules with respect to historic sites, with respect to visual, harmony, well, it goes away, because that does not substantially change the nature of that tower. And so that's what you have. Perhaps even more importantly, I think, is so many of you out there over the years have been able to tell local communities, hey, we will protect you because we will create a stealth installation. So that stealth installation becomes a flagpole, or it becomes, in the case of one community, they made it a large pencil. In others, they're screening, whether it's a tree, etc. But going forward, under this new collocation by right, there's nothing that prevents the industry from taking what was agreed with you, the local government, you, the local planner, and you, the local community, as a stealth installation. There's nothing now that prevents them from coming in and adding this new addition. And so one of the things that I think all of you need to be mindful of is that when the industry comes and tells you, hey, this will be just fine, we can give you a stealth offering, I think you have every right to say to them, how can you guarantee me that a stealth offering today, a stealth deployment today will be a stealth deployment in the future? Because under this new section, this collocation by statute, I'm told that I cannot deny. So how can I say to the community, oh, don't worry, this will always be stealth? And then finally, here's one of the things that worries us very much is that here's a typical, and I think, I don't have a highlighter here. Yeah, somewhere around here. I thought I did. Oh, never mind. Hopefully you can see. But if you look there, you can actually see some very nicely screened wireless devices on the outside of this rooftop here. And what would happen, though, under this new rule is, again, that camouflage in the tradition goes away. Now you're saying, wait a second, Jerry, that's more than 20 feet. That's right. That's right. What I'm trying to show you here is evolving sites. And this is really what's troublesome. So I come in the first, I come in the 1st of January, and I say I'm going to exercise my collocation by right, and I'm going to do something that's 18 feet, so I'm under the 20, or it's under 10%, or whatever the number is we happen to come up with. And then 6 months later, now I'm going to come back in on June 1st or July the 1st, and I'm going to supplement it again and say, well, my structure is no longer X, it was X plus, X plus 18, and I can go another, 9% of what X plus 18 is. So that's one of the other real fears, is that you get this evolving nature of these sites. Give you an example. So this is a home, a DAS deployment in a neighborhood. So it'll drill down a little bit, and you can see it here. So there's the DAS, and that's how it was done. But in time, under these rules, now I don't think anybody's going to do this, but I think we've got every right to point out to the FCC that unless they make clarifications, that's exactly what's going to happen. And then if you look down at the base, you see all those boxes, because remember, each one of these DAS deployments have got basically 3 components, right? You've got the antenna, then you've got the box that interacts and brings the power in, and that's where it converts over to a wireline service to be carried back. We have these boxes down here on the ground because there was a DAS site out in California where they actually had the things down, and we have the local news report did a show showing kids actually running into these boxes on their bicycles. So again, we don't think that we're guilty of hyperbole when we say this is what you might be looking at. And again, these are the types of things that I think you have every right as a planner to ask, well, wait a second, how is this going to work in the future? I mean, how are you going to protect us? How are we going to protect the community? How do we do this? How do we keep faith with our local community when we allow you to bring these things in and do it in such a way that preserves the integrity of the neighborhood while also ensuring that people have access to these services, which is equally important. I'm not trying to denigrate that or discount that one bit. So what I think we believe that you should be expecting, so we told you what you should be expecting at the federal level, which is this new FCC proceeding. We think at the local level you should be expecting litigation. We think that you should be expecting additional actions or challenges to local ordinances, particularly your local ordinances with respect to collocation. So I would really suggest that when you're done this call, one of those emails or memos that you might send might be to your city attorney and say, hey, are you aware of this new law, and have we in fact looked at our collocation rules? Or perhaps even better, you can tell them what your collocation rules are and suggest that maybe they need to be examined to see whether or not they would fit the new world, or how you might adjust to it. We've already seen one company amend a complaint against the local community in New York alleging a violation of Section 1455. Again, that's the collocation by statute, which says you cannot deny and must approve. You should also expect significant misinformation to be distributed with respect to Section 1455. Again, you'll see things along the lines that it prevents a locality from even requiring a collocation application. That is not true. So if you find that there have been collocations made in your community and people haven't even come in and filed an application, then you still have the right to enforce there. There's nothing in the statute nor in the FCC staff advice that says that you do not have to have an application for a collocation. So don't be bullied on that. Make sure that you enforce that the best you can. And again, this is where Ben and I got to know one another. Want to make very clear that states are also addressing these types of issues. And what's happening is that the industry, I think, is coming to understand that what they thought was a knockout punch in Section 1455 wasn't nearly the knockout that they thought it was. And so now they're going to the states to try to impact or define the terms there. Now, I apologize for just taking a second, but it's important for everyone to understand. In the wireless world, federal law is king. But there's nothing that prevents states from improving from the industry standpoint on federal law. So when I talked about the shot clock creating a 90-day presumptive reasonable time period for collocations and a 150-day presumptive reasonable time period for new towers, shame on me, what I didn't clarify is that's only in the absence of shorter terms or shorter durations under state law. If your state law says that you have to act, or your code, your local code says that you have to act within 60 days, then the 150 days that federal law creates is not of any help to you. You've got to live with 60. And again, I know that there are states out there with shorter time periods. You have to live with that shorter time period. The other thing is that in the law between state and local governments, there's a very old concept in the law that local governments are the creatures of the state, right? So constitutionally, there is a recognition that there are states and there's a federal government. There's really not a recognition so much that there's a local government. And so what states choose to do with respect to local government, again, we've got very few appeals to the feds on that, other than if it happened to impact a constitutional right. And so you need to be very aware that while people like the APA and APWA and the Conference of Mayors and League of Cities, NATOA, may do a terrific job of fighting and defending local government authority at the federal level, while that fight is going on, you can lose everything at the state level. And the problem is today, localities are now seeing efforts at the state level to significantly restrict control over wireless placements. And we may, in fact, find conflicts between state and federal law, but as I just said to you, if the conflict is such that it improves or is more restrictive or obligatory on the local government's part, that's fine. It just can't be less. I'll give you an example of this type of legislation took place out in California. And again, 6409, 1455, we use them interchangeable, but here we are talking about the whole idea of what that collocation by statute language means, and it fills it in. It's AB 162. Now that has been moved to a 2-year bill, and so that thread is gone, but it's there. It's there. And again, these are points that I will defer to our California colleagues. You can read this. But again, it goes into greater detail. It talks about things at the state level that you don't even maybe get to at the federal level. And again, this California standard defines what is a substantial change, and today it allows a locality to do it. I will tell you in other locations that's not the case. So, changing something from a stealth facility to a non-stealth, is something that needs to be protected, and I would hope that all of you would do something if you can at the local level. Again, DAS is another thing that's being pushed very hard, and it's a unique challenge. There's some cites to some individual cases in California that we've been involved in. But again, understand if you're not in California and you're elsewhere, the real challenge with DAS is that there's right-of-way implications. That is, people want to be in your rights-of-way. They want to be up on top of your poles. They want to be in your street vaults, etc. And how do you go about protecting yourself on that? Here's a map that's probably woefully out of date already, but you can see just in the course of literally 6 months, we've already seen legislation passed in 3 states, and it's pending. Well, I guess Ben, you said you're now passed, right, in New Hampshire? So we've got it pending in North Carolina, Georgia, Wisconsin, Missouri, Washington, and California. And if it's anything like we saw with state cable franchising laws, I suspect that the next session of most state legislatures, you will find this. So if your state is in blue right now, I couldn't encourage you more to reach out to your state league of cities or to your own advocates up in the state capitol, and let them know that you fully suspect that there will be dangerous co-location legislation coming, and would they simply allow you to participate to outline the problems. So again, I'm going to skip through AB 162 because that's all California information, and I'd rather get to our answers. But again, what do we think that you need to do? One, we think at the state level, just as at the federal level, you need to ensure that your representatives understand the problems with the industry proposed legislation. Let them understand that it's hard enough to do these sightings. Many times these sightings are negotiations, and if you have co-location by right or co-location by statute, it will be very difficult for you to be able to, in fact, keep faith with both the provider and the community. And hopefully most local elected officials, most state elected officials, they're going to understand that mostly what we do in the planning process is compromise, right? It's to respect the needs of all, and understanding that in respecting the needs for all, sometimes both sides have got to give a little. And please keep up to date on possible PUC proceedings, but the bottom line is that you need to educate legislators before legislation is introduced, because at the state level, things move at a mercurial rate. And if you wait till the legislation is introduced, typically then it's too late. We also think that you should review and update your ordinances in light of Section 1455, that is the collocation by statute. We think that it would make great sense for APA to be one of our leaders in creating a coalition to educate the FCC and Congress on these different rulemakings and how they are likely to impact communities. And again, the nicest thing about having planners is that you come at it from an educated experience and an unbiased experience. Because, I mean, if you're a planner, you understand the need for broadband technologies being available in your community, because absent broadband availability, then you're going to have a hard time competing in the world. But yet at the same time, you can look around the world, as planners tend to do, not just within the U.S. You can look around the world and you can see how other locations, other countries, and cities and communities within this country have in fact deployed all these technologies without being visually offensive to the community that's going to be served by those facilities. And again, when this thing comes up, we hope that you'll help us act at the FCC. So I say questions here, and I also give you an example of a paper that was written by a couple of my colleagues, which will do all that. But if it's okay with you, I'm going to blow through in 5 minutes and then we'll have plenty of time for questions. What's happening with satellite dish placement under OTarde? OTarde is an acronym for Over-the-Air Receptacle Device. And in 1996, the Congress directed the FCC to promulgate regulations to prohibit restrictions that impair a viewer, and that's important, viewer's ability to receive video programming services through devices designed to receive over the air. So it's not just a satellite dish, but it could also be an antenna. I will tell you that the Commission has sort of blown right by the word viewer, and they now say that it applies to any device that will allow you to receive and send things over the air. And their justification was, well, you know, if you're looking at the internet, then in fact you're a viewer. You're not a viewer of video, but you're a viewer of text. The FCC adopted their rules, 47 Code of Federal Regulations 1.4000. That's the over-the-air receptacle devices, and you know, it started off really talking about tenants, and then it went into homeowners associations, and now it is citywide. And again, as I mentioned, it was expanded to include two-way fixed radios. And there was a case called In-Ray Continental Airlines. Those of you from Boston may remember that had to do with Logan Airport trying to limit where they could put their Wi-Fi services there. And that's when the FCC said, no, we're going to say that this is any kind of a wireless device, and it just does not simply have to be for video. So this is the rule. The rule preempts any restriction governing a particular property that impairs the installation, maintenance, or use of an OTarde, right? So a dish or an antenna. Okay, and any restriction includes, but it's not limited to, state or local law or regulation, including zoning, land use, or building regulations, private covenants, homeowner association type covenants, lease provisions, or any other similar restriction. And the rule only applies to restrictions that would be for property within the exclusive use or control of the antenna user or the OTarde user, where the user has a direct or indirect ownership or leasehold interest in the property. The rule does not address restrictions in common areas, so there's no protection for common areas, and the rule gives rights to both tenants and property owners. And then, you know, a restriction would be something that unreasonably delays or prevents installation, maintenance, or use of the OTarde, or unreasonably increases the cost of installation, maintenance, or use, or precludes the reception or transmission of an acceptable quality signal. So let me put that in English. You can put in rules so long as they don't delay the installation, they don't they don't unreasonably delay the installation, they don't unreasonably increase the cost of that installation, or the rules don't somehow impair the reception or the transmission of the signal quality that the device is there for. You know, so again, let me go through this. There are two exceptions to the OTarde rules. There's one for public safety, and there's also one to preserve historic or prehistoric or a historic district. You know, the FCC has read these exceptions very narrowly. The burden to demonstrate no impairment is on the party that seeks to maintain or impose the restriction, and that's vitally important in the three cases I'm about to talk to, because until the local government can demonstrate that it does not impair, the rule is stayed. And two, it can't take enforcement action if the FCC petition or there is a court case pending. And again, the FCC has yet to find for one of the creators of the barriers. It's found every time it's reviewed a case to the end, it is found for the antenna user. So currently there are four proceedings pending at the FCC. SBCA, and again, you all know that acronym because you deal with them. That's the Satellite Broadcast Association. They've challenged Philadelphia's ordinance, they've challenged Chicago's ordinance, and they've challenged Boston's ordinance. Each of those ordinances, and perhaps I'm guilty here, and in full disclosure, my colleague represents Philadelphia, and I represent Boston in this matter. But I do believe that a fair reading of each of those ordinances says that if you can put a dish or an antenna somewhere other than on the front of a building, and you can do it in such a way that does not cost you an unreasonable additional amount of money, or does not cause you an unreasonable delay in having the deployment, and does not cause you any kind of signal quality, then you can't put it on the front of the building. That's pretty much what all three of them say. Now, others may argue, but that's the intent. That it's a satellite, it's a preferential location ordinance that says that if you can put it somewhere else, and it's not an undue burden in terms of time, money, or signal carriage, then you've got to put it somewhere else. And those have been stayed. Now, they've been stayed for some time. City of Philadelphia is coming up on about 2 years since it's been able to enforce. The City of Chicago is about 15 months, and the City of Boston is about 13 months. Now, interestingly enough, the City of Boston hasn't even had a chance to reply yet. The FCC's been sitting on it. So, you know, they're telling us we've got a shot clock to act within 90 and 150 days. That's what a reasonable period of time is. In the case of Boston, they're now over 400 days without even giving the city an opportunity to reply. And then finally, the SBCA has also petitioned the FCC to change its rules. Currently, you only are protected in deploying an OTarde device in an area that's under the exclusive control of the user. The SBCA says that that rule should not be able to be carried over to local rules, that was a rule that was put in place to try to limit the Fifth Amendment challenge by property owners, landlords, for instance, to ensure that a tenant didn't have any claim for space outside of the demised premises, and they believe that it should, in fact, not be enforceable by a local ordinance. Local government has replied pretty strongly that no, it's the way it is, because if you don't have exclusive control over the area, then how do we know who's responsible when the thing blows over in a windstorm and hits somebody or simply falls off? Or who do we go after when it has to be removed? So here's the SPCA versus Philadelphia, and again, there's just more detail in what's happened that talks about what the law says. And again, so April in 2012 is when the SPCA came in and asked for the OTarde rules to be changed. And where we stand right now is pending. Philadelphia's is pending. Chicago's a state pending resolution of Philadelphia. Boston, no action has been taken to date, and the rulemaking petition is pending. At some point, we expect that the Commission is going to act on a rulemaking petition or decide the Philadelphia matter. We have no idea, and we have no idea will action on the petition for rulemaking serve as a dismissal or an opening of a new proposal. NPRM stands for Notice of Proposed Rulemaking. So we'll have to see. But again, from a planner standpoint, please understand that what we thought were pretty clear rights that were preserved for local government are being challenged left and right now at the FCC. And, you know, as far as industry is concerned, they're basically winning because they're winning by having the matter never even resolved. So with that, I'll stop. Please, I thank you again for any of you that are still awake. I was hoping Ben would give me a hard time every once in a while, just so you wouldn't hear the monotony of the same voice. But if there's questions or answers, they're there. And Brittany told me that I have to put my ugly mug up for when we're doing the questions, so that if folks don't get a satisfactory answer, please feel free to email me, or if you wanted any of those other information, please feel free. And Ben, I think I turn it back over to you to read questions or to tell me where I need to go next.
Thanks, Jerry. Actually, I want to give a really short update on the situation in New Hampshire, and thanks to you, we were able to intercede in this, even though it had already passed our Senate and had come out of committee in the House. It just happens to be that because you alerted us and I happen to be friends with the committee chairman where it was in the House, we were able to get a floor amendment in the House, which yesterday our Senate agreed with, so it's on its way to the governor, and we were able to deal with the issues you pointed out about the iterative increases in height or width of these facilities, and also the problem of stealth or camouflage. So the way our bill now, which I expect will become law, reads is that any modification to an existing camouflaged or stealth facility that would defeat that camouflage would in fact require local review. So it's not exempt from local review. So we feel pretty good about that, and thanks to you for alerting us.
Bravo, that's awesome.
And I want to reemphasize a point you made, and that was about involving your state municipal leagues and also your APA chapter in this. If you're not involved directly with the legislature, talk to your legislative committee and your APA chapter. Get them involved. Make sure they know that this is happening. This is really, really important. Question I have for you, Jerry, is related to the timing, and you pointed out with regard to the shot clock and state or local regulations that state or local regulations can identify a shorter review time than the shot clock. My understanding, though, and for example in New Hampshire, a planning board has to approve an application within 65 days of accepting jurisdiction. But the shot clock, if I understand correctly, the clock starts ticking as soon as a complete application is submitted, even before the jurisdiction is accepted. Is that right?
That's exactly correct. So being lawyers, as Ben is as well, one of the things that we want to always emphasize is that there are important terms there. So it's a complete application starts the clock. But if you have a bifurcated, which a lot of local governments have, where the planning may do part of it, the zoning may do part of it, yeah, you don't get two shot clocks. It's a unified shot clock, and you have to meet the terms of it. Now, again, I want to say this because I think sometimes I come off as an industry basher, and that doesn't do you any good. I will say that I have yet to find a case where there's an issue that people know there's going to be an issue where the industry participant has not agreed to a mutual extension. Think about it. It makes sense that they ought to do that, because if they don't grant you an extension of time to address these things, then you're almost bound to deny. And if you deny in writing and you can substantiate the record that there was an ambiguity or there was a lack of clarity, and you sought the opportunity to address that and the industry wouldn't give it, I don't think I want to defend that if I'm the industry in front of a court, right? I mean, if our greatest defense is that if we act reasonably, and if we document that we're acting reasonably, because again, it's not that you act reasonably, it's that you can prove that you acted reasonably. So make sure that you're documenting these things. I mean, I'm sure that there are many folks that are on this call that have more than once in their life bad-mouthed their city or county attorney for all the paperwork. But it helps. It helps. And so if you do not have a tickler system set up where you know the date that you deem that to be a completed application, and you don't have that end date somewhere alerting you that, hey, you've only got 30 days to act on this, or 20 days, or whatever it is, you need to put something like that in place.
Okay, we've got a lot of great questions from attendees. I'm going to start with one from Rush Wikis. I hope I have the pronunciation right. And he asks, how is it that states such as Vermont have very few wireless towers? Is it a matter of market forces at work, topography, or regulation?
I don't know. I suspect that it has to do with population. I mean, again, in fairness to the industry, towers cost a lot of money to put up, and if there's not enough demand, then you try to come up with the most efficient and economic way to provide those services. I don't know if anybody's on the phone from Virginia or from Maryland, but I love to use Fairfax County and Montgomery County as two examples of communities that have pretty robust zoning and planning requirements. And yet, because of the economics of those two communities, it's funny, industry finds a way to comply because there's a return on that. So I'm sorry, I think you said the gentleman's name was Russ. Russ, so I think that might be it's simply a matter of economics. Now, the problem for the industry is this though. When I pay my Verizon account in Bethesda, Maryland, and I look at that map that they provide me of service coverage, it says to me that Vermont is covered. So they've got to meet their sort of contractual obligations to me when I go up there. So, but again, it's a terrific question. I guess the only thing that I can definitively say is that I can show you places that have been accused of being terribly over-regulatory, and that has not prevented them from, in fact, deploying, at least 4 generations of high-quality wireless services.
I wonder, too, if in Vermont it might be a case of the existence of the statewide Act 250, which imposes an additional layer of review for certain kinds of development, including wireless facilities. I was the director of a regional planning commission that used to be bi-state, and it straddled the Connecticut River between New Hampshire and Vermont, so I got some familiarity with the Vermont laws. And when the 96 Act passed, there was a lot of concern that the towers were all going to go on the New Hampshire side, because why would you put them in Vermont and have to face Act 250?
Because at some point the towers on the New Hampshire side aren't going to reach far enough in.
Next question from Michelle Wrench. Do home rule municipalities have different standards than non-home rule?
With respect to the shot clock applies regardless of your status, right?
So,
so it's a federal law that is applied across the board. Now, with respect to and I'll just use your very good question as a way to broach another area, and that is, or reemphasize an area that I talked about. You are responsible for meeting the most stringent time period, and that time period may be set by the feds, it may be set by state law, or it may be set in your own code, right? And many times what we find is people get hung by their own codes. And so I don't know if I've got a really short time period in my code. I think I might share with the powers that be, whether it be the executive director of the of the legislative body at the city council, county council, town council, whatever it might be. I mean, if I've got a really short time period, I might say, hey, you know what? The industry accepted this at the federal level. Why don't we give ourselves the same amount of time? There's no rule that says you can't expand yours to be consistent with the feds. You just, again, if it's shorter, you're bound by it. If it's longer, you don't get the benefit of it. You've got to act within the 90 days for a collocation, 150 days for a new tower siting, unless, again, as I said, your time period is shorter.
Okay, from Clayton Comstock, we have this question. Any issues with municipalities requiring that an abandoned tower be removed? For instance, if the tower owner is still active but no carriers have antennae on the tower for more than 1 year?
It's a really good question. It's a really good question, Clayton, and this is where, if you don't mind, we'll take a second to answer two ways. It depends on what hat you're wearing. If you're wearing the hat of the property owner on which that tower is standing, and you know, you're being paid based upon the number of carriers that are on there, and you know, you've got a term in your contract that says, hey, by the way, you're entitled to X amount and you're not getting it, well, then you can enforce those kind of contractual obligations. With respect to whether or not you're able to remove something based upon its being in use, I can't answer that question without knowing what your state and local laws say, but I suspect the answer is no, that you probably couldn't enforce the removal.
And would you say that because typically abandonment requires some demonstration of intent to abandon, which is difficult to prove?
Ben, it's nice to have co-counsel on this. Absolutely correct. There is that intent, and the other thing is that suppose, if we could think back to the very first slide that I showed, and if I knew how to do this quickly, I would do it, right? I mean, if we go back to this very first slide, right? You've got, no, what do we know what's happening? We know that there is an increased demand of sites coming down the pike. We know that for a fact. So I'm not so sure whether if a tower is empty today that I couldn't make a very good case that in fact I'm out there as the tower owner looking to build excess capacity for the future. So you know, now if the tower's falling down or the tower's an eyesore, I'm not telling you not to be aggressive, but if it's being maintained, I'm sure I'm looking to buy that headache.
Okay, Elizabeth Ledet, and again, pronunciation I hope I have correct, asks, I heard that there was a cell tower proposed for Yellowstone Park within view of Old Faithful. Will any of these rules changes affect a site like that? I'm assuming this is on federal land. Yes, Elizabeth, that's a wonderful question, and the terrible section that I showed you, section 6409, was in a piece of legislation that dealt with taxes and a lot of other things. The section right after 6409, and I may be 6410, I just don't have it committed to memory, did talk about aggressively deploying wireless technologies on federal lands. And so I wouldn't be surprised if, in fact, there is a tower that might be sited there. Now, that being said, you know, a lot of times the towers can be camouflaged and need to be camouflaged. Well, now I say that, and then we can talk about the problem with the loss of stealth type of characterization. But you know, so I suspect that, but that's true. But you know, in fairness, when you and I go to national parks, we want to have cell service, right? I mean, so I mean, you got to get it somehow, and so I think that there's you know, there's got to be an effort to preserve the integrity of the environment. But I think people more and more are expecting to have access to wireless services. I know, for instance, we represented the city of Yuma in battling a carrier down there, and in fact, we were able to get them. They created a cell tower down by the OK Corral area, and we were able to make them. They were going to camouflage it in an old water tank, like a railroad water tank, and we were able to make them sort of comply with what the look of one of those tanks would be in the day of the OK Corral time. So I suspect that if it's going in a national park, there will be requirements that it be shielded to the greatest extent possible. Okay, we have a question about stealth from my friend Anna Brynick. she asks, to clarify, can these additions be done in a like manner if agreed to at time of initial approval? That is, future additions would be done in accordance with stealth standards?
That's a wonderful question, and I don't know the answer to that, Anna. And you just demonstrated, by the way, why we need planners at the table as we prepare to address these issues with the FCC. And Ben, I'm going to paraphrase to make sure I've got Anna's question right, because it's brilliant, and that is, can I, as a local zoning authority, a local planning authority, can I approve a cell tower deployment that is stealth, contingent upon any co-locations being made on that tower, preserving the stealth characteristics? And I don't know, quite honestly, right now, how to answer that question, because if I could, I will let me simply get back to the language of the of 6409. So it says here, a state or local government may not deny and shall approve eligible facilities requests for a modification of an existing, let me close this so I can read it, an existing wireless tower or base station that does not substantially change the physical, right? It's not the physical appearance, but it's the physical dimensions of the tower or the base station. So while I think that your question is extraordinarily reasonable and your plan makes great sense, as I look at Section 1455A, I cannot, if I were to be your counsel, guarantee you that that would be an enforceable term and that you might not be subject to litigation if you try to deny the co-location based upon the prior agreement to keep it stealth or whatever the characteristics were.
Okay, a question from Amanda Orenchuk.
Well, Ben, do you agree with my reading on that, or?
I do.
Okay.
I can't come to a solid conclusion on this.
Okay.
Amanda asks, how is collocation defined? Does it have to be with another wireless facility, or can it be on a water tower or some other utility?
Ah, fantastic, fantastic. Are you sure? No, I don't want to leave the webinar. No, I messed up there. One of the problems is, Amanda, that collocation is not really defined. It's a modification of an existing wireless tower. So that's the collocation is the modification. And a wireless tower or base station. So you're asking about a water tower. Well, under the rules right now and under the current FCC definitions, a wireless tower is a tower that was put up for the primary purpose of supporting wireless devices. That's not what a water tower is. It's not what a rooftop is. And so the question is whether or not that tower or that base station would a water tower meet that definition? And we think that right now the answer is it's certainly not a lock. That's what we're worried that, but the FCC is given authority to implement this, and we think that there will be a push for that type of expansion going forward. Now, I want to go back to what I talked about before and saying, especially with a water tower, typically with a water tower, you're wearing two different hats, right? Because typically the people that own water towers are the local government. And there are things that you can do as the property owner that you might not be able to do as the local regulator. And so one of the things that you want to do, I think, immediately is if you ever do a deal with any of these cell providers to be up on one of your water towers, you always want to make sure that there is something in place with respect to co-locations, if for no other reason, to increase the rent that you're being paid based upon the number of other folks that are up there. So that goes without saying. But I'm hearing arguments And that's what Ben will tell you, that's what we lawyers do. We argue with each other as to how these things might play out. I mean, there are some people out there that are worried that absent a collocation clause in a municipal a contract, lease, and or license with a tower company, you might not be able to limit the number of co-locators on a site. So I think you want to clearly address it in contract. In terms of whether or not you still have regulatory authority, I think that you can demonstrate, or we'll probably get more clearance before the summer's out from the FCC. But as of right now, it's not clear that whatever the device is that's being used to host the co-location, whether or not that fits into the current definition of an existing tower or an existing base station.
So if I could ask you to clarify something, recalling one of the examples you showed, and it was of a fairly low-lying building at an intersection that had some nicely camouflaged antenna array. So I guess under the our historical, this doesn't have a long history, interpretation of the law, that building was not built primarily for the purpose of being a tower. So collocation would not be as of right. But are you suggesting then that's the picture? Are you suggesting then that the FCC is moving in a different direction now?
I'm suggesting that the industry would make the case. First of all, what you have here is in fact an extension of a current roof to serve as a tower. So it's not the building itself. You're looking at this sort of mini tower behind it. So it in fact would. I don't know if you can see my screen, but this whole part here is sort of a rooftop extension above that could be considered a tower. So your point is well taken. That that it's not crystal clear, and I apologize. I mean, the question is until we have more definition of these things and more clarification, I think that you need to anticipate that the industry will come to you and will make those claims. And I think you've got every right to ask them to show and define or demonstrate that their application meets this. So when it's a wireless tower, I think you've got the right to them to say, well, wait a second, is this a wireless tower under the FCC's definition? We're not sure it is. Can you help, prove that out to us? Or is this a base station? Prove that out to us.
We have a simple statutory question from Jack Wilhelm. Do you define days as business days or calendar days?
Oh, it's calendar days. Calendar days, Jack.
Okay.
It's calendar days with the recognition that recognized federal holidays. If the due date is the recognized federal holiday, then it goes to the next. In that case, it goes to the next business day.
Okay, and
so
from
all days count until you get to the end. So the deadline can't fall on a federal holiday or a weekend.
Okay, including Saturday.
Right. Don't cut it that close. Jack, why are you cutting it that close? See, this is why lawyers either lose their hair or gray prematurely, because you got people like Jack asking us that question because we know exactly what you're thinking there, Jack. Go ahead.
James Garofalo asks and this is regarding OTards, if the outside 4 inches of the townhouse are common property, does that restrict OTarde devices?
Absolutely, absolutely. Absolutely. If the outside 4 inches are, yes.
They're common property.
Again, common property isn't the term of art. The term of art is that the area where the device is installed has to be under the exclusive control of the viewer. Now, James, I want to make it very clear that the FCC has its own view of real estate law. Almost every apartment building reserves to the common ownership each of the balconies so that they can enforce rules and regulations over that area. The FCC doesn't. The FCC views that as under the exclusive control of the homeowner. I will tell you that there was a case at the FCC where the homeowner wanted to put, I'm sorry, not the homeowner, but the it was a townhome development. So in this condo townhome type development, each homeowner or property owner was responsible for the maintenance of their own roof. So while it was a common roof, each person had their own responsibilities for maintaining it. And in that case, the commission actually found that the person had a right to deploy the satellite dish there over the flat prohibition by the homeowner association. So again, it's exclusive control is the operating term, but it's exclusive control from the FCC standpoint.
Okay, we have a lot more questions in just a little more time.
Wow, that's great. You guys are wonderful.
Christine Moran asks, from New Jersey, is there anything that could be done in New Jersey because collocation has been exempted from site plan review under most circumstances?
Is there anything that can be done in New Jersey? Yeah, change the law.
Talk to your legislators.
Yeah, and look, let's be honest, right? You guys saw my whole presentation, and most of it you were bored to death, but you like the photos. So take that lesson for yourself. Take photos. Show them why you need to have some sort of control, and take your mayor with you, right? Okay, Ben, I'm sorry.
Okay, so from, let's see, I'm going to give someone a chance who hasn't asked a question before. From Sarah Schneider, do you have information about modification of towers or base stations on federal government property? Do similar laws apply, or have cases about towers and base stations on federal property gone to court?
Sarah, I've never represented the GSA. I've worked with them in the past as property owners, government property owner advocates on issues, but I've never represented the GSA or any state GSA. So I can't really cite to a lot of cases. I can tell you that there have been laws that have been passed at the federal level that encourage the GSA to make federal government buildings available and available at a reduced rate at cost. And again, that was passed as part of the same bill that in which 6409 was passed, was this other language that talked about making federal facilities and federal grounds available for wireless devices and wireless towers.
And I think this will be our last question because we're just about out of time. This is from Cade Havik. At the beginning, it was mentioned that a greater distribution of towers was necessary to meet increasing data transmission requirements. That sounds like new tower locations, not co-locations. What am I missing? Are there ways to control proximity of new and/or co-located towers?
Kate, what a great question. And you think you got me. She thinks she caught me. And Ben, you set me up with this being the last question. Way to go. Nice guy. Nice guy. They're like, oh, this guy. Kate, the answer is this, that historically, companies have put their own towers up, or they have worked with tower companies to put them up, and they've each sort of had their own. What you're finding more and more is because more companies need to be in more areas, that there's a lot more co-locating between providers. So my Sprint tower that was exclusively Sprint 5 years ago may today support AT&T and Verizon, because that Sprint provider gets to also co-locate on the AT&T and Verizon. So we're talking about more sites. I think the great majority of them will be, in fact, co-located because they will better utilize existing towers. That being said, I don't want to mislead anyone. There are a significant number of new sites, whether they're towers, whether they're rooftop deployments, whether this new DAS sort of infrastructure. More are coming, but again, because of the speed to market and the efficiency from the carrier standpoint that a collocation offers, that's why I think you'll see many collocations as well as new towers.
Well, Jerry, before I turn it back to Brittany, I want to thank you for taking the time today to really inform us with this, some alarming material. And speaking on behalf of the planning community, it's really great to have people like you at our back.
Thank you. What a nice thing to say. Thanks, Ben.
All right. Yeah, thank you, Ben and Jerry, for the presentation. I'm going to switch it back over to me, and I'm going to go over just a couple reminders on how you can submit your CM credits for attending today's event. Okay, so for those of you who are still with us, to log your CM credits for attending today's webcast, please go to www.planning.org/CM and select today's date, which is Friday, June 7th. And then select today's webcast, which is Impacts on Local Control of Wireless Facilities of New Federal Law, FCC Guidance, and State Legislative Proposals. This webcast is available for 1.5 CM credits. Also, we are recording today's webcast, so you will be able to find a recording of this webcast on our YouTube channel. So with that, this concludes our session for today, and I want to thank everyone again for attending.
Thank you, Brittany. Bye-bye.
Bye.
Hey, Brittany, you still there?
Yeah, I am. I'm just going to give people a moment to jot down the site to get the recording and how to log their CM credits, and then I'm going to log off. So thank you.
Okay.